I'm Tom Cosgrove, Senior Vice President of Public Affairs and Knowledge Exchange here at Farm Credit East. Today we're going to be talking about the new overtime rule from the Department of Labor as well as some other federal labor topics. But before I introduce the topic and our presenter, I want to acknowledge our internal sponsor for today's webinar from our financial services and consulting programs. As this overtime rule, which is really at the center of today's discussion, is developed, our financial services staff have really been front and center in terms of keeping tabs on it along with our knowledge exchange team. And that's particularly true for our payroll staff because they're the ones who are going to be working with Farm Credit East customers to implement the changes required by the new rule. So please call or visit us online if you're interested in learning more about our payroll services. So as we talk about the implementation of this rule, we're fortunate to have with us today Chris Schulte, an associate with the law firm of C.J. Lake in Washington, D.C. Chris specializes in wage and hour, H-2A, H-2B, and tax issues, as well as working on public policy issues involving Congress and federal agencies. His work relates to immigration, agriculture, and a number of other subject areas. With degrees from Harvard and Georgetown Law, he's also worked for the U.S. Attorney's Office for the District of Columbia and clerked for trial and appellate courts in New Hampshire and New York. In terms of his policy work, Chris works with a number of stakeholder groups, but I would like to mention one of them, which is the National Council of Agricultural Employers, which Farm Credit East is a member of, and I know some of their members have joined us today. So with that, Chris, I'll turn it over to you for the presentation.
Here we go. So the new overtime rule was just announced a few weeks ago in mid-May. It had been proposed a year ago, and then there was a considerable amount of comment last summer. There were public meetings and a great deal of stakeholder involvement, particularly among employer groups who are concerned with the potential impact on the rule and especially the added costs and burdens and all the changes it would mean inside their workforces. The rule was originally expected to cover, have an effect on 4.6 million people. They scaled it back slightly so that the new salary threshold level would be a little bit lower than the one originally proposed. We'll discuss that in a second. But now it's expected to cover 4.2 million workers, 600,000 of those in the Northeast. Wages in the Northeast, as I'm sure you're all too well aware, are on average higher than they would be in places like the South or the Southeast. So there would be slightly less effect because people are already being paid slightly higher rates than they would in those places, but it's still definitely going to have a huge impact on the states in New England, New York, and New Jersey. More than half the affected workers are in retail and restaurants. Of the other half, it would be a lot of smaller businesses, those with, and especially on seasonal businesses, a lot of companies will pay workers on a salary basis knowing that there's going to be a busy time when workers will be making basically slightly less per hour than they would have at other times. But because they have that fixed salary, they have reliable pay through the winter and through the off-season, and workers like that. They can take a week off during hunting season, they can come in fewer hours during the winter when it's slower, and then when the growing season ramps back up, they're there and ready to go back to work, but they have that steady level of pay so that they can cover mortgages and daycare and issues like that. So it will affect a lot of smaller businesses like that. They're projecting that it will be a $1.1 billion increase each year spread across the country, and that's a significant amount of pay without necessarily more revenue coming in, so it's something that will be felt by employers. We're going to talk about what was changed, look a little bit more at who will be affected, and then specifically in the context of what it's going to mean for agricultural employers. Just some background to this. The overtime rule comes out of the Fair Labor Standards Act. That was a product of the New Deal. It was passed in 1938 under President Roosevelt, at the heart of the Depression. It sets, among other things, the federal minimum wage, currently at $7.25 an hour. It's been a few years since they've updated that. There's been a lot of discussion about changing that at the federal level. Fairly unlikely to move in the near term at the federal level. So a lot of states, New York very recently has moved to increase their state minimum wage. And under the FLSA, the other provision that we're all familiar with now, but was not the law prior to that, was the idea of the 40-hour work week, and pay of time and a half for hours worked above that, unless there's a particular exemption that applied. There are state laws in place as well. Most of the states in the area would have their own minimum wage. New Hampshire doesn't have one. It varies. It's $8.38 in New Jersey, $9 in New York, soon to increase. And so to the extent that there's a state minimum wage that's higher than the federal minimum wage, obviously you need to pay the state law. And so each of these is a floor, but not a ceiling. So if you have a higher state wage, you need to comply with both sets of law. And so you would have to pay the higher state wage as a minimum. And then just to add a further layer to that, any employers that are using H-2A workers, they need to be paying the adverse effect wage rate, the AWR, to any of their foreign workers, but also to any U.S. workers in corresponding employment. And we'll talk about that a little bit later, kind of who is and who is not in corresponding employment. That's been a hot topic in the last year or two with federal wage and hour, the people that enforce the H-2A rules. So for most of the states, it's going to be $11.74 an hour, which you can see is a premium wage, is well above the minimum wage, either the federal or the state wage. The New Jersey wage is slightly lower, but essentially the same at $11.66 this year. That wage changes every year. They will usually announce it toward the end of December, right around Christmas. It's the result of a survey that the U.S. Department of Agriculture does, and they'll publish that wage, and as soon as the wage takes effect, basically the workers need to be paid that as of that day. So it goes into effect immediately upon publication by the Department of Labor. So we mentioned that there are some exemptions, some situations in which the normal rule of time and a half for work over 40 hours applies. And this is really what the change was that the department just issued. They were actually tweaking the definition of one of the exemptions. One of the main exemptions, and the one that's going to be most relevant to most of you, is the agricultural exemption. There are two definitions of agriculture, and this is both in the IRS regulations as well as in the Wage and Hour, the Fair Labor Standards Act regulations. There's primary agriculture, what you would think of, kind of working in the fields, weeding, harvesting, planting, picking apples, traditional, classic. That's clearly within the definition. That's agricultural. If a worker works 60 hours a week, you would pay them, they call it straight pay. So it's going to be whatever the wages that you've negotiated with them that's higher than the minimum wage or the adverse effect wage rate, exactly that wage for the first hour as well as for the 60th hour, no time and a half for that. Then there's secondary ag, which is related to agriculture but is not sort of kind of hands in the dirt, kind of working the fields more specifically. That's where the edges get a little bit less clear and you get into some gray areas the further you get from kind of the work in the field. But the language that they use for the Department of Labor is that it's a practice that is performed as an incident to or in conjunction with the farming operations, which not terribly helpful. Usually it comes up where you have to kind of look at the specific examples. There have been cases litigated on this where, and it usually comes up in the context where an employer has not paid the time and a half, premium for the overtime premium. Wage and Hour comes in, or they're sued by the individual workers or legal services saying, you should have paid them overtime, you're not properly exempt, and then they'll fight out whether they are within the definition of the agricultural exemption or not. The main kind of two areas that you're looking at, the two factors they want would be that it's performed by a farmer or on a farm. So if it's work done where the employer is not the actual grower, or the work is done basically away from the farm, that's where you start to get into the issues. And so people that will have issues where it's a closer call, something where a grower is also running a farm stand or is taking the material to a farmer's market, and so their workers are employed by the farmer, but it's done away from the farm. They're working in a farmer's market, kind of, they've taken the goods into a neighboring town and are basically just manning a cash register somewhere else while they're selling the produce. That's where it could become, it could get outside this definition and become non-exempt, and so they would need to be paid time and a half in that pay period for work that they had done beyond that. some, supplying things through CSA. Another issue is where they are handling the produce of another grower. This comes up in the nursery context quite often, where a nursery has sort of produced their own flowers, but has then taken on things that were grown by somebody else and then sold them out to the public. The Department of Labor has said, well, then now you're basically a retailer or operation as opposed to a growing operation. And then you get into details of, okay, how far along the process from basically a seed to a seedling to a proper plant, if you've taken it from, basically nothing, doesn't even have to be a seed, but kind of from a fairly newly planted plant to a mature plant, you've taken part in growing, you've added value to it and transformed it. There are cases that will say that is agriculture. You've done growing operations more than just turning something around, just flipping somebody else's plant. You take a fully grown potted geranium and you buy it for $5, sell it for $7, keep the profit. Now you're basically, you're operating more like a garden center as opposed to a grower. So it gets into situations like that where it's splitting hairs a little bit of kind of, how much work is enough. There are exceptions within the exception where you need to buy plants in to fulfill a contract on an emergency basis. It's not something that you do as a normal practice, but you have a contract to sell a certain number of trees to a developer or a certain amount of crop to your purchaser, to your customer. There's a frost, there's a flood, you lose part of your crop and you need to buy in from a neighboring farm to kind of fill that order. They would say that's acceptable. It's sort of a one-time emergency response. That's okay, and you haven't lost your ag exemption for the workers that are working that time. This final point, and we'll move on to the new part of the overtime rule and loop back to the ag issue a little bit later, but it's specific to the worker and then specific to the pay period. So it's not something that once you have that exception, you're an agricultural worker, you're exempt, that will stay with them forever. They can lose that for that pay period and then have it again for the next pay period, and you could have two workers working side by side, one who handles basically, if you're an apple orchard, one is packing only the apples that are picked from that orchard, but then the other one handles a handful of apples that have come in from a neighboring farm that they've asked you to pack as a favor. So the worker that handles the outside crop could potentially lose the overtime exemption and be entitled to pay and a half, whereas the other worker would still be exempt. They're standing side by side. It's just specific to that pay period and that worker. So the exemption that was changed under the new rule is usually referred to as the executive, administrative, or professional, the EAP exemption. There are some other occupations that are swept into that for computer workers or for outside sales staff, but usually EAP is what's going to cover that. So these are people that have, and there's some definitions that we'll come up to in a second of the types of duties that they need to be engaged in, but the main idea is that they are paid on a salary basis. That's the main thing that distinguishes them. It's both the type of work they do, how they're paid, and how much they're paid. Those are the factors. There are different exemptions also. As you know, for tipped wait staff, they're not entitled to the minimum wage. You'll see that, for most workers, they would be paid $7.25. Wait staff could be paid something closer to $4 an hour, but they get to keep their tips. So they make it up through other means, but they're only guaranteed a smaller dollar figure. And then there are exemptions for the overtime rule, particularly for truck drivers, motor carrier exemption. You could have more than one exemption, and this is something that we're gonna talk about here, so that even the changes that DOL has announced, if it means that some of your employees would qualify for both, and even if you lose one of the exemptions, that worker could still be exempt if they're covered by the other. The example here is if someone's an agricultural supervisor or they're an office staff person that's located on the farm, a back office worker that handles your payroll, they're located on the farm and paid on a salary basis, so they would be exempt, for doing administrative work. It's basically white-collar work. You're working in an office, handling the paychecks, handling payroll, processing paperwork, things like that would normally be exempt. But the employer is also agricultural, and they're doing work that is what we would say is incident to or in conjunction with the farming operation, so they would be separately exempt as agriculture. So even if they lose one or the other, so that, you know, in the one case, if they are not paid enough to meet the new salary threshold for the new EAP exemption, they could still be agricultural. Or if they're paid enough so that they have both exemptions in place under the new rule, but they're doing payroll for workers who have handled outside crops or who are working in a farmer's market or something like that, that those workers would lose the exemption, and because some of their work relates to that, there's the potential that they would lose their exemption, they would still be protected under the EAP. So as long as you have one exemption, you're fine, and they can be paid on the regular basis and not entitled to overtime. So if you have 2 exemptions, 3 exemptions, or 4, you know, however it adds up, you know, exempt is exempt. So as long as you have 1 or more, they're fine, and they do not need to be paid overtime. The issue comes up where they lose all of their exemptions, and so that's when they need to be tracking hours and paying the overtime for them. And so as we discussed, it's specific to the work. It comes and goes, and it's tied to a given pay period. You can get overtime for one pay period and then work 60 hours in the next pay period, but be completely exempt and be paid straight time for that. So it's a significant headache for the bookkeeping staff, because they need to know and they need to work with the crew supervisors and the people that are out there watching the workers to know how to handle this issue on a paycheck by paycheck basis to make sure they're doing it correctly. Because if wage and hour comes through or a State Department of Labor investigator comes through, that's how they will look at it. They will go through with a fine-tooth comb week by week and make sure that it was paid correctly, you know, for every single paycheck. So these are the 3 factors for the EAP exemption, and this is under the current rule that's in place today and has been in place for a number of years. Test 1 is the salary basis test. The worker is paid a fixed amount regardless of how many hours they're worked. That's what we think of as a salary. Makes sense, you know, that you don't track their hours. They get paid the same, you know, whether they come in for 20 hours that week or they come in for 60 hours that week. You know, that's what they make. It's basically, you either figure out an amount for the whole year and divide that into the number of paychecks, or sort of set a guaranteed weekly, bi-weekly, or monthly draw and kind of go from there. And that they know for a fact they're going to make that amount no matter how hard they work, and so that way they don't have to worry about it. If they're sending an email in the evening, handling a phone call on the weekend, they don't have to track those hours. It's all part of their job. They're paid an amount for their entire job. Number 2 is the duties test. And out of those 3, the E, the A, and the P, they're slightly different definitions, but essentially kind of common sense. Executive is going to be somebody that has the power to control operations. This could be, it doesn't have to be a CEO or somebody in a suit. It could be an executive, could be a crew leader or a supervisor, but somebody that has the ability to make decisions that will affect the business. They can hire or fire, or even recommend hiring or firing if they're not the sort of the buck stops here, the absolute decider. But they have a role in kind of making executive decisions and how the operation or how the farm will run. Administrative is, as we described, it could be back office, basically white collar, people that are working on payroll, people that are working, you know, with checks, with finance, anything like that. You know, a lot of, you know, secretaries, bookkeepers, that's going to be covered usually by the administrative portion of it. Professional is more, you know, lawyers, doctors, dentists, things like that. Less likely to come into play, but kind of people with particular skills. And so that could be, you know, we could look into the facts of it, but if you have kind of a, you know, an agronomist or, you know, an expert or somebody that has higher education training in a certain area, that could potentially be covered as professional. So they're not necessarily supervising other people or controlling things like that or working in the office setting, but potentially they could be covered under a definition of professional. And so this Wage and Hour Fact Sheet 17A has some more information about that. If you go to the Wage and Hour website, they collect all of their fact sheets. They're designed, most of them are 2 or 3 pages. They're designed to kind of give an overview to employers. It's not going to necessarily answer the detailed questions or kind of get down to the ground level of how your operation is run, but it'll give you kind of their thinking and the general parameters of what the definitions they're looking for would be. And then the 3rd test is the salary level test, and this is what they changed in the rule. that they just announced last month. Under the current rule, which has been the wage level that's been in place since 2004, which is partly what was motivating the Department of Labor to make the change now, workers needed to be paid at least $455 every week, which worked out to $23,660 for the year. So again, depending on the industry and the part of the country, that's decent money in some places. If you're working closer to New York City or San Francisco or DC, something like that, not a terribly lot of money, but it was set nationwide that they needed to make at least that. So any amount that was paid in excess of that would meet the test. And that part, under the current definition that's in place today, that does not include bonuses or commissions. That was just straight pay. Any bonuses would be above and beyond that. This is the proposal for the new rule. And to keep in mind as we discuss this, this will not take effect until December 1, 2016 at the earliest. And that's without actions by Congress to block it or defund it. And that's without any court challenges where a judge would order the department not to put it into effect for a certain amount of time. And both of those are in play. There are challenges to it both through the courts right now and through Congress. We'll discuss that in a second. But for right now, they've given employers a certain amount of time, and it's frankly more lead time than you usually get on a regulatory change. They'll often give you 30 or 60 days to figure it out and comply, and some things they'll just say it's effective immediately upon publication. Here they've given people a little bit of time to adjust to it and kind of figure out how to structure their business to comply. They've moved the salary basis from $23,660 all the way up to $47,476. So they've more than doubled the salary threshold. That's where you get the 4.2 million workers that are going to be affected. So these are people that are earning somewhere in that gap in between. So they could have been making $25,000 or $30,000 and have been perfectly salary exempt before. Now they're going to lose that exemption unless they're making $47,476 as the magic number. They've allowed, for the first time, the use of commissions or bonuses, and these are usually paid on at least a quarterly basis. Sometimes they're referred to as non-discretionary bonuses that, say you sell a certain target, a bonus is triggered in your contract. So it's not something where the employer can say, I feel like you've done a good job, I'm going to just cut you a check for this amount of money because that feels right. So their definitions and kind of what kind of bonuses or commissions are included, but that's a little bit in the weeds, but that can cover up to 10% of that. So basically, say about $4,700 out of the $47,000 could be made up of these bonuses or commissions. They will have future updates every 3 years. It's tied to the lowest income census group, which is almost always going to be the South. So if wages there go up and they track these average wages of salary employees, then there will be future increases that they will publish. There were no changes in the duties test. That's important. There were concerns that they would move to something like, for instance, in the state of California, they have particular tests. For the regular test here, it just has to be your primary duty. So basically, more than half the time, you are an administrative worker or professional or executive. It doesn't have to be 100% of what you do, but for the most part, that's how you would primarily identify. They don't look at the title of your job. They don't care about what the employer calls the worker. It really looks to what they do. But as long as it's basically 50% plus 1 minute, the majority of your time spent doing that, that was fine. The concern was that they would try to document it down to, okay, 90% of your time or 75% of your time has to be spent doing this, so that employers would have to track every single activity and kind of have people that were, for instance, in a restaurant setting, you could be the manager, but then also you're clearing tables or seating people or kind of checking on things in the kitchen or placing orders. The restaurant associations were terrified that this was going to make it impossible to do business because they would have people that were doing different kinds of activities and, tracking them and making sure that, on a minute-to-minute basis, they're staying above that 75 or 90% threshold. They just said, this is too complicated. We're not going to regulate down to that level. As long as it's still your primary duty, you're fine. The only change we're making is to the salary test. And so as we discussed, Congress is discussing bills right now. They've been proposed to block this, and so that could come either as a standalone bill saying we disapprove of this regulation, and they would get enough votes, send it to the president, because it's his administration that's put out the rule. Surprise, surprise, he would veto it, and the sense is that they do not necessarily have the 60% majority that they would need to override the presidential veto, or the two-thirds majority. They would need a supermajority to basically overrule that, and they don't have the numbers. It would be basically probably a party line vote where most of the Republican members would vote in favor of blocking the rule. Most of the Democrats would support the rule. It would kind of stalemate, and so that's not likely to pass. If they included it on something that was what they call a must-pass bill, like an appropriations bill to keep it funded, keep the government from shutting down, sometimes they'll put in policy riders that will say, we're giving money to the Department of Labor to do this, this, and this, but none of the money that we give you can be used to enforce this rule. They call it a policy rider, or a no such funds provision, where they would be able to block the department from enforcing it. So the rule would still exist, it would be on the books, but the department would not be allowed to spend any money to actually enforce it or to push this rule. So in effect, while that spending bill is in place from October 1 to the following end of September, the rule would effectively not be in place against employers, but would still be out there. And there's the possibility of litigation. Groups like the Chamber of Commerce and some of the trade associations have discussed court challenges to it, challenging either the way that it was introduced, whether DOL had authority to do so, issues like that. And so depending on where they file that, if they choose certain venues, likely in the South or in more conservative districts, it's possible they could get a court to block that. So we'll see. We'll keep tracking that. In responding to this, I mean, there's some amount of time between now and December, and for most growers that will be after the season. So the next time you'll see this on a large scale is going to be next spring. But if you have salary workers that stay on salary over the winter, it could affect you beginning on December 1 in that first paycheck that covers December 1 and any time after. And there's different ways, and there's no one right way. You need to decide what's right for your business and kind of what you can afford to do, and what will keep your workforce happy and productive. For these executive employees that are earning in that gap, this is really who it's going to affect. If you have workers that are making already $50,000 and are exempt based on their salary, this won't change anything for you. You're already well above the new hire threshold, so it doesn't really matter where they set it, you're already in the clear. But it's really for people that are in that window that it's going to be an issue. For people that are close to that, say they're making $45,000 now, something like that, the employer may say, it's close enough and I don't want to have to be tracking their hours or worrying about this, so just to kind of keep them exactly as they are now, I'm just going to give them a raise and bump up their salary to this $47,476 level or above, and then everything will be square and I can just continue running the business as it is. It's a hit, it's going to cost me money, but I can afford to do it because we're close to that. And it could be that they structure the bonus system. If you look into the fine print and figure out ways to do bonuses or commissions to get them to that point, maybe that's a way to kind of reach that threshold down. For employees that are earning well below that are earning maybe $25,000 or $24,000 that are currently exempt but would not be exempt, and you'd have to double their pay to even catch up to this exemption, employers face a different choice. Again, they're still free to pay them up to that new threshold, but if that's not going to be reasonable or cost effective, they can basically change them to an hourly status and track their hours worked. So, this is seen as a demotion for a lot of employees. They go from, this idea of having a salary, you feel like an executive or you're kind of part of the team or part of the management structure, going back to being an hourly worker. It's going to sting for some people, even if they're making more money or even if they're making the same money. It's still, as a matter of pride, will affect some people. So in tracking the hours worked, the thing to be careful of is if these people, not just the sort of when they clock in and clock out, but just kind of being careful of people that are getting emails in off hours or get pulled in for emergency basis over the weekend. You're going to need to keep track of all of those hours and make sure they're paid for all of them, and then either keep them working the same schedule and just be prepared to pay them time and a half for hours above the 40-hour threshold, or find ways to restructure it and either hire more people and spread the work out, or just say, you know, we're only going to work for 40 hours, and once you get to 40, you have to stop, and we're going to track it and enforce it because we don't want to have to pay overtime or time and a half. So when the time's up, you're done, and that's as much work as you've done for the week. It comes down to a business choice and kind of modeling it either way. That if the amount of overtime that you expect that you're going to pay is sufficient, you know, maybe you pay them up to the new threshold and cover it that way. But if it's, you know, only every so often that they go above 40 hours, then maybe you track it and then try to either pay that or manage that as you go. On the ag overtime exemption, we basically covered this a little bit earlier. Cultivation, growing, and harvesting, what you would think of as agriculture. If you stopped somebody and said, you know, or showed them somebody working on a farm, they'd say that's farm work, that's agricultural, you're fine, you're preparing it for market. It becomes an issue after something's been harvested, but before it gets processed. Obviously, if you sell it, you know, if you grow tomatoes, you pick them, load them up, put them on a truck, send them off. They travel over the highway, they make it to Pittsburgh, they go into a factory there at the Heinz plant where they turn it into ketchup. The people that are working there are factory workers, they're not farm workers. And so at some point along that journey from, you know, picking it off the tomato plant to it going into a ketchup bottle, it's gone from agriculture to non-agriculture. It's not a clear, bright line. It can be frustrating, and so it's difficult to kind of predict where that would be. The discussion that they have, basically, the idea is where the commodity has kind of come to rest. You know, that it's been either delivered to the shipping company or loaded onto the truck and kind of sent off, or put into cold storage, kind of, you know, put in a place where it stops being something that's just been picked and is something that is now a commodity and not a crop. There's an exemption for this that's built into the statute that was negotiated by people in Congress from the Northeast years and years ago, is for cider house workers. So once the apples are picked and they've kind of gone into storage or sitting in bins, it wouldn't normally be agricultural. And even if you're handling, you know, other people's apples, as we've discussed, that's going to lose the agricultural exemption. But, you know, people that are running cider press operations, there's a specific provision in the statute that says cider work is exempt as agricultural. It wouldn't normally have been, but because of that language added, it is. And then secondary ag we talked about is this incident to or in conjunction with the farming operations. There's some minimum wage exemptions that could also apply. Those aren't really affected by the rule change that we talked about from DOL. Sort of if it's you know, family farms, very small farms, some local work. These are things that have been the law for a number of years. So, you know, if it's something that you're already familiar with and taking advantage of, the change in the law won't affect this. If it's not something that applies to you, it still won't. And this is where we talked to the idea of the unfinished state for the crop. You know, something that, you know, kind of a tomato or an apple that's sort of in its raw form. It's just been picked. It exists, but before it's stored or kind of packed up or moved on. And then there are things that are, you know, on-farm transportation. You know, somebody that's driving a truck and bringing workers from your housing to the fields. People that are mechanics that are fixing tractors. So it applies while it's done on the farm or for the farmer. If there's a repair shop in town and you sort of take a tractor there and they're working there in the garage, they're doing the same work that they would be doing on the farm, but because their employer is not the farm and they're not doing it at the farm, that same work of repairing the tractor would not be exempt. Most processing is similarly not exempt, where you, like we talked about, you know, the sort of the Heinz factory, you know, cider being the built-in exception, and then the concern with handling crops that are grown by others. There's some small exceptions, but the trouble is you don't necessarily know until you fight it in court to find out if you meet those exceptions. Wage and Hour will assume that you do not and will basically enforce the regular rule, and it's up to you to prove that that doesn't apply to you. And so that's that contract fulfillment where, but for bringing in somebody else's crops to fulfill one of your contracts, you wouldn't be able to because of, you know, frost or drought or rain. And then there's something called the de minimis rule, where if it's just a very small number and there's no bright line definition, because God forbid they make it easy to be able to comply with this, but if it's not hard and fast, sometimes 2% will fit, sometimes 5% will fit, and then other times 2% is too high and it's not de minimis. So, but basically it's that idea, just a few harvested fruits or vegetables or plants in a nursery setting that are brought in from somebody else and then resold, where it's not really changing the nature of your business. It's on a very small nature, but they will sometimes allow that. But again, you won't know until it goes to court. And then things that would be essential to the work, there have been cases that have said, and it's in the comments to the regulations, that because it's done off-site and the employer is someone else, it's not going to be treated as secondary ag. There was an irrigation company, for instance, that was setting up an operation where they were going to divert water to a farm, but the work was done off the farm and kind of getting the water to them, and their employer was the irrigation company. They found that even though it's essential to the product, it's clearly incident to or in conjunction with, because it's connected inherently with the farming operation, that sort of thing would not be covered, and so there would not be an exemption for them. And again, if someone is exempt under the ag exemption, the change to the new rule will not affect them for the most part. You won't care. You will still be ag exempt. If you are today, you will be on December 1st. That part of the rule will not change. If you're consistently overtime exempt, then that's fine. If it's not consistently, that there are times where they will take in product from someone else, or they may have duties that take them off the farm, but they would still be exempt because they're paid on a salary basis and paid above this level. It's a crew leader, but then they will go to farmers markets or do some deliveries, things like that. But so they're both an administrative or an executive professional and paid at the salary level, and usually ag exempt. It could be an issue because during those times, if they are making $25,000 and you don't increase their wages to catch up to this $47,000 level, or don't increase their salary, they would not be exempt under that, and they could lose during some pay periods their ag exemption. So you would need to be careful of that in a way that you wouldn't before, because it's kind of a reserve parachute or belt and suspenders, however you want to look at it, that you were covered both ways and would have plenty of room. We'll just touch quickly on the H-2A visa program. Try to catch up here. There's some employers that are in it and are going to be well familiar with this and have been using it for a number of years. There are people that do not use the program at all, hire only U.S. or local workers. Basically, it's a visa program that allows you to bring in foreign workers on a seasonal basis. It's generally up to 9 or 10 months. It's tied to a specific season or part of, you can bring in people either for the entire life cycle of a crop from planting to harvesting, or just bring in harvest workers for a shorter time. Tied to a particular location or a particular employer. If you bring in workers, you can't have them go work for the farm up the way, or you can't move them to another place. Or if you have, you're growing, carrots in upstate New York, but then you also have an apple orchard in Maine, you can't just switch them from one to the other. It's tied to a particular job in a particular place. You're required to recruit U.S. workers as part of the job to make sure that they're not able, willing, and qualified U.S. workers in that area that could or would be willing to do the job. If you do hire them and they're doing, if they're in what they call corresponding employment, you need to offer them the same benefits as U.S. workers. So they need to be paid that adverse effect wage rate we talked about, the 1174 or 1166 in New Jersey. If they are not from that area, basically within a reasonable commuting area, you need to offer them housing in the same way that you have to provide housing to your foreign workers. Traditionally, corresponding employment meant that you were in the same occupation, you're doing the same job, and you could tell they're side by side, these people are doing the same job day in, day out, all week. The department has expanded this through their enforcement efforts. The rules that they last issued in 2010 said that they were sticking with the previous rule. However, in enforcing it these days, they say if you do any one thing that's listed in the job order, you're now a corresponding employee. So if you have, and you have to list all of the possible jobs that you would do, because if you work outside that job order, you're in big trouble and can be debarred from the program. But say you have high school kids that are there just to kind of sweep up around the area, but in your definition for what the more experienced guys, the H-2A workers, will be doing, you mentioned that they would also be sweeping or cleaning or something that potentially could cover what the U.S. worker is doing. Well, now that guy that was happy to make $7.25 an hour, you have to be paying him the $11.74 because he gets pulled into corresponding employment because of that 1 point of overlap. Transportation, you need to pay for the workers to come in, their travel costs, visa costs, their hotels along the way, food to get from their home village to your farm in the U.S. and then back. Provide housing while they're here, local transportation. 3/4 guarantee is that you need to offer 3/4 of the hours listed in the job contract. So it's not on a week-to-week basis. So if you have a week that's a complete washout, it's raining, they can't do work any day, that's fine. But over the course of, say, it's a 10-month contract, they need to do work for basically 7.5 months out of that full 10. So you're looking at it as the whole contract, and it needs to be offered. So if they break their leg and they can't do work, the work is still offered, they're just not able to do it. And so on the pay stubs, you need to reflect both the hours that were worked and the hours that were offered on each pay stub. And then at the end of the season, you have to notify both agencies if they leave. If it's the end of the season, you don't have to tell them. If they depart early, either abscond, take another, if it's a U.S. worker that takes another job, foreign worker that decides that they're homesick and they want to go home, you have to report that in to both of those agencies. Failing to do so is it's a fairly small fine. I mean, it's maybe $10 or it's just a nominal fine. The concern is if you don't, the DOL will come in later and say, well, we don't know that they left on that day. You have to pay them 3/4 of the hours. And it's like, that guy's been gone for 6 months. I have no idea where he is. Like, well, you still have to pay him all of these hours even though he's long gone. So reporting it to them basically stops the clock on the 3/4 guarantee. We talked about the corresponding employment. There's something called an Areola issue. You need to pay their transportation costs in that first pay period. This comes out of a court decision that the failure to do so, to the extent that it pushes their wages below the $7.25 an hour, they treat that as a violation of the FLSA. This has been expanded so that basically for any of the inbound expenses, even though the rules say you pay those at the halfway point of the contract, DOL's position today is that you have to pay that in that first paycheck. So as soon as they arrive, they're paid for all of their travel costs, hotel, meals, visas, anything that they've paid along the way, you're going to have to reimburse that up front, fund them that money. And we've seen a significant amount of processing delays at the different agencies this year. A lot of that is in response to problems in the H-2B program, but it's bled over so that people that are using ag workers are seeing the same problems. This is a whole separate topic that we don't really have time to get into in depth, but Obamacare, the Affordable Care Act, is going to cover a lot of employers. There have been delays, but this year they're starting to see that roll out. So their reporting requirements for those using H-2A workers, because they are, quote, lawfully present in the U.S., they're treated just like U.S. workers would be. And there's a dispute in the definition of what is a seasonal worker. What we think of as a season is basically kind of spring through fall, something like that. The definition in the statute is 120 days. If a worker is there for less than that, you don't have to count them toward your 50 full-time worker threshold. And then there's the 180-day rule that's come out of IRS for purposes of figuring out if they're full-time or part-time for whether you need to be offering them coverage or not. But separate issue for another time. And for any employer of any size, you need to give them and your workers an exchange notice at the time of hire, or if it's a returning worker, even when they come back at the beginning of the season. And you can go to the DOL website. They have model forms that you can just sort of fill in the blanks and provide to your workers that just tells them, this is our company information. We either do or do not offer coverage, and here's how to contact the local state exchange. You can just, if you're in Massachusetts, you're covered by, Romney Care, or, the sort of the predecessor to the ACA. If you're in Connecticut or New York, they would go to the state exchange or the federal exchange as applicable and figure out how to get coverage there. There are I-9 requirements that you're all familiar with. This is something that the paperwork needs to be completed 100% correctly. They have they've been, so USCIS is supposed to have backed off on some of its enforcement efforts toward agriculture and been prioritizing criminal aliens, people that have committed crimes and are also in the country illegally, as opposed to just worksite audits. But that has not really reduced the number of I-9 audits, making sure that people have, done their paperwork correctly and taken care of, getting all the I's dotted and T's crossed on those forms. OSHA is a constant issue on farm, making sure that the workers are safe and taken care of. They put out the week before the overtime rule a change to how some of the reporting is handled, pushing to electronic reporting, making searchable databases so people can check and see which employers have accident rates or have had issues in the past. That will be a gradual rollout over the next 2 to 3 years. So there's time to kind of track how those summaries are submitted, and it depends primarily on the size of the company as to what information needs to be provided and when. Just as a matter of general advice for employers, being prepared early, taking part in webinars like this, working with groups like Farm Credit East or NCAE, you're going to have a leg up. Having the best defense is having the paperwork in order, kind of ideally doing self-audit, going through your own paperwork, making sure that you have everything in order before the government comes through and tells you what you've done wrong. So if you already know, that gives you a chance to correct it so that you can make it through an audit and have either no violations or very few. That's your best case scenario. They're long processes for some of these things. If you're going to come into the H-2A program for the first time, you're going to need to line up housing, be prepared. Most employers will file through an agent, either through a trade association, someone like New England Apple Council, or through outside companies that file paperwork for a number of different employers. These are people that move, hundreds or thousands of applications a year, and so they will have the software and be able to fill it in and have the contacts at the state workforce agency to kind of smooth the process along and get things going. But it does take a certain amount of time to get that up and running. You can't decide a few weeks before the season, you know what, I think I'm going to give this a try. You really need to be planning months ahead of time. And these are complicated things. You need to document what you have. Even if you've done everything perfectly right, if you can't prove it later when the auditor comes or when you're in court, it's as though it never happened. So, be overly cautious. If it seems like, well, everyone will understand what I meant by this, not true. They will look at it in the worst possible light, so document it. Write memos to the file, write down what you're thinking. If you have a worker that has been a problem, document they were late on this day, they refused to do work on this day, so that if you want to fire them later, you're not just firing them and they say, oh, they let me go because they're discriminating or they just didn't like me or because I complained about something. You can go back and say, that's not true. Here's 3 weeks worth of complaints. We gave him these opportunities, we followed these rules, and we let him go properly. These are not things that you can comply with by accident. They're very complicated, and some of it's internally contradictory, frankly. So you need to be careful and really, know the rules and know what your practices are. Stay on top of your HR staff. Make sure that everybody's doing this correctly as you go. And with that, I will. We can open it up to questions if people have, anything that they want to talk about in particular.
Great, Chris. Well, thanks so much. Some great information there. And yes, we have gotten a number of questions in, so I'm going to kind of try to get right through them so we can hopefully get to most of them. I would remind folks that we are going to be posting a recording of this, and if for some reason we don't get to all the questions, we would certainly try to follow up with Chris to get a response to you. So Chris, as we look at the classification of employees relative to ag or not, one of the ways that gets reflected is in terms of the forms that are filled out. This is a little bit into the weeds, but in terms of a 941 versus a 943 for an ag employee, and I've had the question from both angles, meaning what if a 943, meaning an ag employee, goes to the farmer's market, uses the cash register, thus, sort of not the production ag duties. And I've also had to ask the other way, that if someone is, in a sense, classified as a non-ag employee, 941, but they are actually doing some ag work, maybe you could help just talk through the issues involved in that situation.
Sure. And it's a little bit, there's sort of the how people are handled for tax purposes, for kind of how they report on these different forms, is not necessarily going to align with the Department of Labor's definitions. Basically, the basic rule for the ag exemption is that you need to be doing agricultural work, or what would fit within that either primary or secondary ag definition, for 100% of the time during that time period. For purposes of reporting as a 941, 943, if you're mostly agricultural, then that's how you're going to identify, that's how it's going to get reported. But for overtime purposes, it's basically a zero tolerance policy for that pay period. So that if you are working in the field, you're doing all of this work, but then you spend 15 minutes out of that week doing, at the farmer's market, filling in, or just doing work, that's not covered by the ag exemption, or handling another farmer's produce, something like that, that worker will lose it, not just for the 15 minutes. Say they've worked 55 hours that week, they don't get straight time for 54 3/4 and then pay overtime for the last part. If you lose it for that pay period, you lose it for the whole pay period. And so they'll be paid straight time up to 40 and then overtime for those last 15 hours at time and a half. So it's a little bit trying to put a square peg in a round hole for some of this, making the definitions line up perfectly. But the basic idea of the ag overtime exemption is they need to be exempt for everything that they've done during that paycheck period.
Okay. We had a couple questions come in related to, I think really would fall in sort of the duties exemption question. So one, in terms of the administrative exemption, looks at, and I think they're quoting from the Department of Labor guidance here, discretion and independent judgment with respect to matters of significance. How does that relate to someone who maybe they're not doing farm labor, but maybe doing paperwork in the office, a clerk, truly administrative type duties? Would that be considered administrative in terms of the purposes of the definition?
It would, and this is where it's tricky, and where, unlike the ag overtime exemption, where, as we said, it has to be 100% of the time, here, as long as it's your primary job, so that if most of what you do would fit into their picture of what the work is, and the definitions here are a lot more vague than they are for the agricultural exemption, again, because it's that 100% zero tolerant policy. They're looking more at the overall job, not just at the job title, but kind of, generally what they do is kind of these white collar in nature, administrative, kind of handling books or payroll. That would fall within the administrative exception for overtime. And again, provided that they meet the other two parts of that test. It's a three-legged stool. So, that they're paid on a salary basis and that they're paid more than the salary level, the $47,476, and their duties they have to meet all three of those. If you have somebody that's doing administrative work, but they're making $35,000 under the new rule, they won't be protected. Or if they're paid $15 an hour and doing administrative work, you're going to have to pay them overtime unless they're ag exempt. But say no other exemptions apply, you would have to pay them overtime, even though they're making more than what this threshold is. Because they're not paid on a salary basis, they would lose that, and so you'd have to pay them overtime. So you look at kind of the overall factors of that. Somebody that's working actually at the farm, so if you contract out to a payroll company or have somebody in town that is a CPA handling this, they're likely not going to get the ag exemption, as opposed to if you have somebody that's located on the farm that's right there doing that work, even though they're never going to have kind of dirt under their fingernails, they're not working on a tractor, they're not working with the crops or even ever handling anything of that, because they're doing work that's incident to or in conjunction with that work on the farm, they could potentially be exempt as ag exempt as well.
Okay, and then I think a similar one where you've got someone who is a production manager, so is involved in actual farming work, but then also because they're a manager, they have some of those duties like being able to hire and fire. Would those folks still be exempt, or do they lose it because they have probably in this case maybe what would be described as executive duties?
So yeah, the fact that they work in agriculture wouldn't take away their job as an executive. So if So say, for instance, somebody that is in a supervisory role, they have the ability to hire and fire and kind of make decisions about, kind of where the workers are going to be working, executive work. The fact that it's a farm doesn't take that away, as opposed to, say, they were making those same kind of choices in managing workers in an auto parts factory, kind of saying, okay, today we're going to work over here, I have to let you go because you're not doing a good job, I'm going to hire this guy on. The fact that it's ag doesn't take it away. You can be doubly exempt, and so in which case, as we said, one exemption is the same as three, but that way if you lose one or more of those, then you could still be exempt as long as you have one of those basics for exemption. But the fact that it's ag as opposed to, industry, or you're managing a restaurant or an office, it wouldn't take it away just because you happen to be working with people that are growers.
Okay, great. A question came in related to the 10% rule, that up to 10% of the non-discretionary bonuses and commissions could be counted toward the $47,000. And so, an example was, you gave an example of someone making $45,000, but let's say they make, even $30,000 in non-discretionary bonuses and commissions. I think one of the angles of this question is, what level of certainty does there need to be that they will make enough to put them over the $47,000 threshold? So it's non-discretionary based in some sense on a performance or meeting sales goals. Do you look at history in that case, or how do you determine whether that 10% can be counted towards the exempt level?
It's a good question, and some of this they haven't really filled in all the details on this. This is the first time that they've really done it, and so it makes it a challenge because, if you structure the base salary ahead of time, you know what they're going to be paid during those times, and then at the end, say, it references kind of making these payments on at least a quarterly basis, so not just at the end of the year. But you can't know what their sales will be, or whether they will do the work to meet the benchmarks to trigger some of these bonuses. So you can't really tell, and you wouldn't have been tracking their hours as you go. So say you go 2 months, 3 months, and you get to the end of it and you realize, oh my gosh, they're going to be a little bit short. I think that's where it's going to make it hard to kind of plan a business based on the bonus. But I think they haven't really thought through kind of how the details of that will be enforced, so that if you have in the past, they have been paid a bonus in this kind of structure of or commissions, or any kind of incentive pay like that, where you have reason to predict that they're going to meet that. You could arguably have this kind of a good faith argument that I really intended to make that. I expected, honestly, that they would have. There should be a safe harbor to that, where if they fall short of that, they don't lose the overtime exemption, because there would be no way to go back and recreate how many hours they would have worked during all those months. So if you can show that there's a reasonable basis for this, they've been paid that for the last 2 years, they always would have made it. For whatever reason this year, say they were sick or had some family health issues, so that they weren't able to do the extra work that would be required to make that threshold up. So that's why their pay would fall slightly below the line. It's hard to tell. I mean, you could get a DOL, a wage and hour auditor, that is just going to take a hard line and say, nope, 47,476, that's it. Anything short of the bar, you're done. Or they could say, well, you really did expect to make that. They were properly a salary employee. They shouldn't lose the exemption, even though they fell a little bit short. You paid them at least 90% of that total and expected that they would have made up the other 10%. So that's reasonable to do. That's something that might have to get fought out in litigation. They can't really kind of even if they've put out extensive FAQs and some publications targeted to small businesses and to employers in general, where they try to talk about this, but they're a little bit light on details for some of the specifics for the bonuses, because that's an important thing. There are a lot of employees that could make that based on kind of the performance of the farm, that you're paid a certain amount, as long as it's predicted and not really, the terms they use are paid on a quarterly basis and non-discretionary. So, I mean, that helps give some idea of what kind of bonuses or what kind of pay structure they're looking for. But there are a lot of things that could fall within that, and there are times, like you said, where they could fall a little bit short, even though they had expected that they would have made it.
Okay, great. So Chris, we're at the end of the hour. If it's all right, we have a bunch more questions, and honestly, we're probably not going to get to all of them, but I'd love to go through a few more with you for another 10 minutes, if that's okay.
As long as it takes. I'll be here and answer as many as you can.
And as I said, we will follow up with other folks who don't get to their questions. You know, I think a lot of people are giving sort of specific examples. We'll try to not get in too many specific instances, but hopefully some of these will shed light on situations on other folks' farms across their territory here. So someone talked about a labor audit that they had, and it was talked about their on-farm processing, but because they added other ingredients, they were considered manufacturing, took them out of the ag exemption. But one of the questions they had was related to their farm store manager. In their farm, they had some additional products based on, you know, in addition to ones that they produced on their farm. So in terms of a farm store that's carrying some outside products, Chris, you talked a little bit about those, you know, that exemptions and de minimis. Where, you know, what guidance would you give on that point?
Yeah, and it's an area where even though there's a kind of a zero tolerance and it's pretty clear, okay, it needs to be ag all the time. The de minimis is an example where they're trying to build in a little bit of flexibility, and in the enforcement they'll say, well, you still look more like a farm than a store. So even though, you know, you have a few products, you could take the position that that's you know, very minor, you know, that it's a de minimis, you know, exception to it, and so you could be okay. The trouble is, as we talked about before, it's tough to plan for that. That, you know, it depends a little bit on the auditor that you get, or how, if you take it to a judge, how the judge will decide it, because the cases have gone both ways, and there's no clear percentage of sales. You know, that if it's below, you know, 1% or 5% or 10%, you know, that it should be okay. Obviously, the higher it is, you know, the more outside products you have, the less likely it is that you'll get it. But we have seen that where it's a, you know, an apple orchard, then as kind of you know, value added, they would have a bakery on site and make fresh apple pies based on the things that they had just picked. Logical thing, you know, a good way to add a source of revenue and respond to what your clients or your customers are looking for, but they're going to say that as soon as you basically transform the apples from their raw, kind of unfinished state into some other product, now it's a bakery and not a farm, or now it's a store and not a farm if you're selling it in other settings. So I would be very careful of it, and, you know, if there's a concern that, you know, look, this might be over the line, or they might say that this work is not exempt, you can limit the number of workers that are doing that work, and then just either cap them at 40 or pay them the overtime, as we talked about as the solution, if they're not going to be making the executive exemption. Just to kind of, you know, have certain workers that are handle that and kind of wall it off. Even if you're you know, you're packing for other growers, if you can sort of run separate lines or have certain people that do that, so it's not kind of infecting or you know, having an impact on your entire workforce, but just have, okay, these 3 people are going to do this. It could be a problem because, you know, if they talk about their paychecks at the end of it, you know, one guy's going to be making more than other people because he's paid time and a half and somebody is paid straight time. So it becomes kind of a personnel management issue. But, you know, if you can kind of quarantine where the violation or where it's going to be treated as non-ag, you know, you can handle your payroll that way. And just to loop back real quick on the issue of the bonuses, that there is a provision in there for what they call a catch-up payment, so that if you had paid 90% up to the threshold just in straight pay and then had the other 10%, and for whatever reason they fall a little bit short, you're allowed to make a payment in that next pay period to kind of get them up to that $47,476. So, I mean, again, they wouldn't have kind of earned the full bonus, but you can kind of, you know, pay the gap and kind of get them to that point. And that DOL has said that will take care of it. That will cover you for that quarter, whatever is missing out of that 10% for that quarter.
Okay. Here's a slightly different take on one. In terms of a grower who is basically growing in conjunction with another producer who share a certain, they're farming the same land, sharing certain amounts of the inputs. So it's clearly ag work, but their question is, because they're sharing some resources, would that be considered handling someone else's crop to the extent that, that there's pooled labor in a situation like that?
It's a good question, and it could come to, it also raises some joint employer issues that, depending on how the workers are supervised, or if their payroll comes only through one company, one of the growers and not the other, and kind of who, things down to kind of who owns the land, is there a lease agreement between the two people that are working the same land, kind of, this has been another area of emphasis for the wage and hour division in the last 12 to 18 months, this idea of joint employer, trying to have more people be potentially liable for wage bills, and try to go after the deep pocket. So say you have those two growers, workers are working there, they're paid and supervised. What we would think of as their employer is farmer A and not farmer B, but because they're working closely together and it's benefiting farmer B, the department is saying, well, farmer B is also their employer, which would be news to them. They've never written a paycheck for them, they didn't hire or fire them, but they could potentially be on the hook if farmer A doesn't pay the workers. So there are issues to do with that.
But yeah, it sounds like that would still be ag work, so you wouldn't, raises a different issue, but you wouldn't lose the ag exemption in terms of handling someone else's produce.
Usually when you see that, the kind of handling somebody else's product, it's kind of after it's been picked, so it's kind of before it's gone into storage. So it's usually in the packing house operation, but it can be even in the nursery operation. So if you are, but it comes to basically whether you are just operating more as a retailer, you're taking in somebody else's work and then profiting by turning around and selling it, as opposed to you're contributing to the growing. Here where the work they're doing is primary ag, the question of kind of who owns the seeds or who would have a right to the crop afterward is a little less important. And there are other exemptions for, things like custom harvester operations, or people in the Midwest that will come in and cut wheat for other people. It's not their land. They don't own the wheat. They're basically cutting somebody else's product. But they've said that's because it's work done on the farm and it's agricultural work, they will generally accept the ag exemption for that work. So here where it's, kind of they're working side by side in the same field, it's kind of, well, whose melons are these and whose are those, who planted them, well, this field's ours, that's yours. Because it's still work on a farm for the farmer, they should still have an argument that that's ag exempt, yeah.
Okay. Chris, we're gonna wrap it up here with one kind of two-part question relating to the salary itself. So it's kind of a general question, but if there is an employee who is overtime exempt, could you pay them a salary, because they are an ag worker, could you pay them a salary under the $47,000, or would you have to track their hours, but then you don't obviously have to pay them overtime? And then I would say the sort of a related question to that is, what if you have a situation where you've got an owner who is drawing maybe a marginal or a small salary? Are they exempt, or would they in effect have to give themselves a raise, if you will, to take them up to the threshold in order to remain exempt?
Yeah, I'll take the second part first. For the owner, it depends kind of how it's done. If it's just, if they own it and they're taking a draw from profits so that they're not an employee, that they are sort of treated as the operator, then it comes to whether it's considered wages or income from the farm. So it gets into more detailed tax questions, kind of, are they structured as an S corporation or a partnership, or how they structure the business. But usually they would be exempt as that. If they're paid separately, that's not a wage, so there isn't an issue of paying time and a half to their wage, because they're not really making a wage. They're just drawing money out of the corporation or out of the farm itself. If they're paying themselves as a wage and kind of, for purposes of their health care or for tax reasons or for other reasons, they're kind of acting as an employee of the company, then they might have to sort of make sure that meets that threshold. If they're relying on that to not pay themselves overtime, but otherwise are getting regular paychecks and kind of handling it that way, then even though they're clearly the executive, they're making the call, they run the operation, to rely on that EAP exemption, they would have to meet the salary threshold as well. And then on the other question of, so ag workers who are not paid, so, and again, this would be, and this is going to be for non-H2A. For if they're H2A workers or corresponding workers, there are separate rules for that. So if it's a U.S. worker on a farm where there are no foreign workers working there, they need to, I mean, you can pay them on a salary basis, but you need to be careful that that the other provisions that we talked about on the minimum wage provision wouldn't be violated by that. So that you could still pay them, say, $30,000. So it's going to be, it would have been above the old threshold, but is now below the new one. So they wouldn't be exempt based on that. But so long as they're ag exempt for every minute of the time that they're there, and they're clearly going to be exempt, you don't ever have to worry about the time and a half on top of it. But you do have to worry that, say they work, it's a crazy week and they work 80 hours one week. So if you divide up their pay for that period by the number of hours, is that going to put them below the $725 or the $863, whatever the applicable state minimum wage is? You just want to be careful that they don't work so many hours in a pay period that it puts them below that. So you wouldn't normally be tracking their hours. They're just, you're hiring them, they're a crew leader or supervisor. They're just meant to kind of, they do their job. If they get phone calls at night, so be it, things like that. That's where they need to be careful that it doesn't push them below that minimum threshold for each hour worked in that pay period. But otherwise, they don't have to worry about salary as opposed to overtime. It can be a steady payment, and so long as they're staying consistently above that minimum for every hour worked, they're fine.
Okay, great. Well, Chris, thanks so much. I think we'll wrap it up at this point. As I said, the folks whose questions we didn't get to, we're going to work with Chris to get some responses on those. Reminder that our, as being shown on the screen right now, the presentation materials and the recording will be available at farmcrediteast.com webinars. And again, Chris, we appreciate your time and the discussion on these topics today. And with that, we will conclude the webinar. Thank you, everyone, for attending.